All right, so welcome to the Appellate Clinic at Public Counsel. My name is Zoe Dolan, and rather than continuing to do the same orientation over and over and over again, I thought, well, let me just record it. I'll start with an overview of what we do here and sort of the appointment process, and then introduce you to the resources that we work with in serving self-represented litigants here at the clinic. So first of all, we have appointments, and to manage litigant expectations and to help people understand and respect lawyers' time, folks are generally told to anticipate appointments of about 20 to 30 minutes as a practical matter. In instances where it's productive, sometimes a lawyer may, at their discretion, extend that period, but normally litigants should expect appointments of about 20 to 30 minutes. We do them in person or on Zoom. You're welcome to come in. We have great offices. You'll have a nice big conference room with windows to yourself. If you choose to come, we can arrange parking for you. Although I understand many people also like to just sign up for a Zoom and work from the comfort of their office or home. Whatever's clever, we can work with your availability. I used to be an active practitioner, so I understand schedules and all of those things. Every sort of week or two, our paralegal, Caitlin, will canvass volunteers for availability. Sometimes appointments get snapped up pretty fast, so if you have an interest, then just respond to her email and let her know. You will see docket numbers along with case names indicating the parties, so you can eyeball those prior to the appointments themselves. Okay, so let me just introduce you to what we mostly work with. All right, so first of all, actually, before you even get into this, you should probably have at your disposal the case docket search for the Second District as well as Los Angeles Superior. You'll have case numbers for any given appointment, and you can just search through them, check the docket, and see, sort of what the most recent situation is and where the litigant is in the process. There's people who see us are self-represented folks, of course. So oftentimes people do need assistance in understanding exactly what they need to do next, and why and how. Similarly, the case docket search for Los Angeles Superior pulls up whatever is going on in the underlying trial court, and you can often check there to see if record designations have been filed or docketed and so forth and so on. So we usually start appointments there just to orient ourselves on where litigants are, and we meet them there. This is our website. We have some FAQs on the homepage for general questions as well as designating the record. We also have a helpful video that I will get to in a second. Just a note for myself. But here are the forms, guides, and samples. Navigate to that tab and you will see our library of resources and materials, which is really sort of the main backbone of what we do here. So as you can see, there is a general info overview. with some very useful guides prepared by the court and the Los Angeles County Bar Association, as well as a sort of quick guide from public counsel from us, and an AI-generated overview, a podcast discussing some of these general things for our audio-based learners. And then the library just proceeds through the appellate process, chunking out each stage of it. And each section is sort of organized the same way. There will be some general resources, and then any specific forms that need to be submitted for that particular stage of the process. You'll start with notice of appeal, proceed to fee waivers. Most folks we see have already had a fee waiver granted in the trial court. Sometimes they need additional assistance. Civil case information statement. This is generally where people need additional assistance, just sort of understanding the process, designation of the record. It helps to facilitate their understanding that an appellate record is, of course, what is in the record before the trial court. That's where many self-represented litigants have challenges, understanding, for example, why they can't include something that was not in the record, and those types of issues. The form itself is also a bit convoluted, frankly. So people often do need additional explanations to understand the difference between a clerk's and reporter's transcript and why they're designating documents for the record in one section and transcripts to be transcribed or produced in another, and so forth. Opening brief section, same idea. A couple of samples, a sample from the court. It's actually very serviceable, very good. And then a regular opening brief template, simplified for folks who really would benefit from just the most bare bones presentation. These open as Word documents they can work directly from. And again, an AI-generated overview, moving to oral argument, and then applications and motions at the bottom or near the bottom. Motion to amend the record designation, motion to vacate dismissals. We try to help folks avoid going into dismissal, which I'll talk about in a minute. But these are some ancillary motion samples, or they open as Word templates as well that people can work from. Again, the most common ones are motion to augment the record, possibly motion to vacate dismissal, and maybe an extension request for either the record designation or for the brief. Respondents and reply briefs. We do not assist with appendices, omission letters, or cert petitions, but we do have those provided if people do want those resources. So the library really was created with three beneficiaries in mind. The first is, of course, the people that we serve and the public, so that they can see everything organized and presented in 2025 fashion on a website. Also for our volunteers, so that people who maybe haven't done a ton of appeals, or newer practitioners, or are volunteering with us for the first time, can step right in and feel comfortable providing the information that we enable them to do. The last thing is, of course, to amalgamate the materials that we train our AIs with. I mentioned some of the overviews and so forth already. And I will get back to that in a minute. Earlier, I mentioned videos. I do an annual presentation at the Los Angeles Law Library. This is an advertisement that we really don't need. Okay. And this walks folks through the appellate process. It's 45 minutes. You're welcome to watch it yourself or refer folks to it if they need some additional clarification or you think they might benefit. And at about 30 minutes in, we start talking about some of the AI tools that I'm about to introduce you to. So we do, provide a little bit of exposure to folks in this video as well to tools that are openly available to the public. This is what one of our podcasts looks like. You open one of the links from the library. They're pretty cool, 10, 12 minutes long. They will walk folks through whatever form, opening brief, record designation, general overview, whatever corresponds to that section. Okay. This is the AI portion. Oh, before I get to that, let me just say, when we provide appointments, there are basically 3 points of contact that you should know about. The first is when litigants initially reach out to us. The second is during the appointment itself. And the third is usually after. When people first reach out to us, we ask them what their legal question or issue is. Then we take a look at their docket to determine what we think might be going on and where we think they could use some assistance if, for example, they're in default or dismissal or there's an upcoming form that they need to submit or that type of thing. And then we do provide them with whatever appears to be most relevant and timely to their inquiry from our library of resources and materials. So for the most part, go ahead and expect, again, most of the folks that you will be seeing at appointments to already have what we think is likely some materials that relate to what they need to be doing next. The second is the appointment itself. We provide legal information and assistance, not full counsel and advice. What our goal remains is to help folks proceed from a notice of appeal through to hopefully as close as we can get to something resembling a reasoned decision on the merits. And we focus on the procedural aspects along the way, getting all the forms in, helping them assemble the record, helping them put their brief together and get everything filed. To the extent that any of our pro bono volunteers may have any particular substantive familiarity with any legal issues that arise, you're more than welcome to suggest guidance or areas for potential research or arguments, that type of thing. We do generally go over briefs during appointments to the extent possible and make some suggestions, for example, on either formatting or organizational issues, or maybe the types of arguments that litigants may want to look into. But we are a clinic for self-represented litigants, and so people do understand and they, sign acknowledgement and everything that they are responsible for what they are submitting. So that's how the appointments go. And then the final point of contact is afterward. Just send some case notes, literally, 2 or 3 sentences, unless anything else needs to be documented or memorialized, indicating just the general nature of the case and the discussion that you had during the appointment. So topically, whether it was the record designation and or the opening brief, or if it was just the opening brief, major themes discussed or that type of thing. And then include in the case notes, which you emailed to Caitlin, any areas that we should follow up with. So for example, in your case notes, you'd say, we discussed designation, or it was a restraining order case or family law case, for example. We discussed the record designation. Caitlin, can you please follow up with the opening brief materials? So you would let us know just sort of the general nature of the case, the subject of the appointment, any additional specific details in your judgment that you feel that we need to memorialize, if any. And then lastly, the next area that we should provide some support on and give them the links for. So we see folks with all different types of cases from all different walks of life. It is very gratifying because everyone is participating in a self-engaged political and legal education. And for the most part, people are very appreciative of any information that we can provide. About half of the folks that we see as of late March 2025 are already using generative AI, sometimes to great effect. We have a class and an AI program for self-represented litigants that we beta trialed at the end for 4 months at the end of 2024. And about 18 folks have access to this assistant, which is public counsel's experimental appellate clinic AI assistant. It starts out, if you click on that suggested prompt, by explaining what it is and what it does, and then you can just ask questions. This is mostly a procedural tool. It does have pretty specific information and knowledge bases, drawing from everything from the templates that we discussed to Title VIII itself. Oh, look at that. I guess it even, yeah. Okay, yeah, it's giving a link to help designating the record. I prompted it to say, I need help with my record designation. Can you help? And it already linked me to a record designation page. So it's pretty good. Legally speaking, it has outperformed me and every one of our volunteers so far on every legal issue with which we have presented it, no matter how arcane. Which can sometimes, helping self-represented litigants can, of course, sometimes put that challenge to the test. And it's pretty good in terms of helping people formulate some of their ideas, conduct research, understand the procedural mechanisms that they're engaging with, and drafting their various documents. Just so you know what it looks like on the inside, it is a pretty normal AI that has instructions to help it understand what it is, what it's doing, what its purpose is for this particular instantiation, and then the actual knowledge files that we discussed. So this tool is open to, right now, the folks who have been through our AI program, and also to all of the volunteers and lawyers who work with us. We definitely encourage you to avail yourself of it. And if you need any familiarization, especially with prompt engineering and optimizing interactions, just let me know. The other tool, and this is widely available to the public, is perplexity.ai. Okay. And Perplexity are basically making a run on Google. It is an AI search engine that is optimized for search, a little bit more than just a normal chat interface that you may be used to. And so after introducing folks to the procedural aspects, to the extent that they are delving into substantive legal research and need some assistance with that, this is the tool that we help them to understand and to maximize as best we can. And as you can see, if you haven't used Perplexity yet, what it will do is, you know, go through a whole bunch of different steps, and then produce a cohesive, hopefully coherent and cogent response, outline form, organized information with various citations. So here I've asked it to educate me on the standards of appellate review in a restraining order case in California, restrict any search to findlaw.com. And here we have substantial evidence for factual findings, abuse of discretion as it applies, de novo review, appellant's burden. So a serviceable response, particularly for a self-represented litigants. And note also, as I said, it's got these footnotes that will cite to specific cases on findlaw.com that it purports to draw from. Obviously, that information needs to be verified, but there are two aspects of this tool that we try to impress upon folks. The first is the prompt engineering, and the second is to make sure that they're using a reasoning model. So if you are unfamiliar, as you saw in our tool, which is not a reasoning model, you have a prompt and then it immediately starts just reflecting back an answer. With Perplexity, in contrast, it has these 12 steps in which it engaged. So it's not just immediately reflecting back an answer, it's doing those other things before it answers. That's important because it drastically increases reliability and accuracy and reduces hallucinations and potential error. So that is the first tip that we impress upon folks if they are using generative AI, to definitely try to look mostly for reasoning models, if not exclusively. And the second is, in terms of prompt engineering, make sure that there are three different elements in the prompt. The first is the legal issues, so the standards of appellate review in a restraining order case, the jurisdiction, California, and then the constraint, restrict any research to findlaw.com, which is a Thomson Reuters maintained database of case law and statutes. So it's hopefully as official and reliable as it gets. So people are not just drawing randomly from the internet. So again, the two main things are ensuring use of reasoning models, and secondly, that three-pronged approach to the prompt that includes the legal issue, the jurisdiction, and the research constraint to calibrate accuracy and reliability. Okay, so I think that is basically it for the general overview. And I will try to make a transcript of this and synthesize it into the training. And then when we do meet after you've seen this, just let me know if you have any specific questions and we can take it from there and get you all set up. Thank you very much for your interest in the Appellate Clinic. We very much look forward to working with you.